Now, you've seen recently a number of news articles, especially now with the whole debacle about sport pesa going to court and the directors accusing each other of this and the other, and revelations that are coming out on, all right, so how much are they able to collect on a daily basis in terms of how much the punters are putting in for bets? How much are they raising per month, per year? How much of that is now going out to pay for services, for example, the owners of the platform, IT services, and the rest, and where those companies are domiciled? Those are conversations that now have emerged. We have also had a conversation before where we talk about how much money is raised locally by companies, and then those companies have some shareholding that is outside the country, and how much of that money is then repatriated outside the country. All those things emanate from things like the kind of agreements that Kenya has made with other countries on taxation and all. So let's just get straight into this conversation on looking at the opaque tax treaties that the Kenya has with other countries. Joining us is the legal officer at the East African Tax and Governance Network, Everlyn Muendo. Good morning, Evelyn.
Morning.
Thank you very much for joining us.
Thank you for having me.
All right, welcome to the Situation Room. Let's start with this whole issue of just definitions. The tax treaties that the country has entered into, and the importance of having such treaties, and then the downside of such treaties.
Okay, so double taxation agreements, or as they are otherwise called, double taxation treaties, are agreements between two countries to pretty much decide on the taxing rights. For instance, they were actually designed to increase cross-border trade so that entities that carry out business in several countries are not taxed on the same income twice. That would be unfair. So they actually have a lot of good value. The intention behind double taxation agreements is actually a good thing to increase cross-border trade and investment. But you also mentioned talking about the downside of double taxation agreements. Now, the downside of double taxation agreements is that they have been widely abused. So what happens is that you'll find multinational entities or multinational companies taking advantage of double taxation agreements between two countries so that they can reduce the amount of tax that they are paying.
How exactly would they do this?
I can give a very good example of the spot pesa case and the double taxation agreement that exists between UK and Kenya.
Yes.
So what was happening is there was the spot pesa company that was operating here. I think it was called Pevan. And then there was SPS, which was actually domiciled in the UK. So what would happen was the UK company was providing software services to the Kenyan company. So the Kenyan company would pay for those software services that it is paying. But the problem with that is how they were pricing those services. They were pricing them in such a way that it was up to 400%. It reached a 400% markup, which means that it wasn't at normal rates. They would overvalue the services, so to speak. And the reason why they were doing that specifically with the UK entity is because under the UK entity, the corporate income tax that they would pay is lower than the threshold that they would pay within Kenya. So they were purposefully shifting their profits from Kenya to the UK to avoid paying their due taxes here.
Were they breaking the law?
No, they weren't breaking the law per se. It isn't illegal per se what they were doing, but it shows that there's a system but there's in fact a problem with some of these double taxation agreements. It shows that Kenya, in effect, through this double taxation agreement with the UK, was signing off its taxing rights. And smart multinational entities that have sharp lawyers and have a lot of resources are taking advantage of such agreements to reduce the amount of taxes that they pay so that they can increase the profits that they have.
But who in this country or which entity forms the body of that is mandated with a watchdogging duty of ensuring that Kenya benefits as much. Well, let me start again. Whereas they want to encourage investment into the country and cooperation and bilateral and multilateral trade, which body ensures that Kenya also benefits through their taxation for the monies that are raised within the country? Who is supposed to oversight all this?
There are actually a number of bodies. Let me put it very simply. It's a group effort. There are a number of bodies that need to work together, that need to be more coordinated, and that need to listen to each other. So the Treasury or the Cabinet Secretary for Finance is the person who's actually given the powers to enter into such double taxation agreements. But the KRA, as the revenue authority body of Kenya, are the people who understand taxation. They're the people on the ground. They're the ones who are charged with collecting revenue. So what needs to happen between these government actors is that there needs to be a cost-benefit analysis. How much are we in fact gaining through these double taxation agreements? How much investment in trade are we gaining? And how much are we losing in terms of revenue collection? And do the pros outweigh the cons? Do the cons outweigh the pros? The other very, very significant body that needs to be more involved in double taxation agreements is the Parliament. The Parliament are the holders of public interest in terms of all the arms of government of Kenya. So they're the ones who are supposed to make sure that at the end of the day, whatever double taxation agreements that Kenya is entering, it should not be against our public interest, that it should not be harmful or have a negative impact towards revenue collection, and which eventually contributes to providing public services to the Kenyan people.
You said that these entities that we do business with, and the example of SportPesa, I think, is a good one. They have smart lawyers, but the people who negotiate these things on our behalf are our ministries of finance. Are we saying we don't have sharp people in that ministry?
That's a good question. I don't want to go ahead and say that we don't have sharp people in the ministry. I don't want to go and say
I'm actually saying we do have very sharp people in that ministry.
Okay. I'm saying that someone is dropping the ball somewhere within this government bodies. Someone is definitely dropping the ball. And a lot of times you'll find that we enter into double taxation agreements not because of proper economic reasons, but sometimes it's also very political. So there's not the benefits are not really considered, and the disadvantages are not really considered. The actual disadvantages and the benefits are not really considered when you get into these agreements. In fact, it's something that even investors have noticed, and they talk about how there's a rush, not only by Kenya, but by a lot of African countries to provide tax incentives blindly without really considering the costs and benefits. In fact, we call it harmful tax competition, where we keep lowering our thresholds for taxes in the name of attracting foreign investment, but we don't actually do any analysis to see, has it actually worked? Have we attracted investment? Is it really the main factor that investors look to whenever they're considering whether this is a good destination for my capital or not, or for my investment or not?
But have our laws actually changed to accommodate this? I mean, I'm talking generally speaking, because the Betting Control and Licensing Board has been there for the longest time. From the time when there was the Spot the Ball contest, charity sweepstake, they've been there. But the entity you mentioned, SportPesa and their ilk, now that business is a totally different ballgame, completely different. And it's different because we are in a time when technology has enabled everything that you want to do to actually be accessed through something as simple as a phone. So it may not have been possible to anticipate what the future held, but what is possible was to have laws that can be, or agreements that can be reviewed periodically to cater for the changing times. Because From what you're saying, it looks like some of these agreements we signed are actually cross-generational, meaning it's signed now and it just continues. Surely there must be a point at which you pause and say, okay, we are this.
Do they have a tenure actually then?
Yes.
The double taxation agreements. Are we saying there's a double taxation agreement signed that will expire after 15 years and then there shall be a review?
Every year
yes. Is a tax agreement signed and that stays?
Thank you. You've actually pointed out one of the biggest issues that we had with the whole Sport Pesa case. The fact that they were actually using a double taxation agreement that was made in 1977, and that it does not necessarily, that it definitely does not apply to the current economic situations right now. You just mentioned a very important issue that we have with double taxation agreements right now the world over. It isn't just in the Kenyan case, but it's also a regional and it's also at global level. And this is the issue of the digital economy and how it affects taxation of income. Because the thing with the Sport Pesa case is that with some of these digital services, it's very hard to determine what the market pricing for these services should be, and therefore what is the standard for it, so that we can also apply the arm's length principle. What are the comparable?
What makes it
prices?
difficult? You say it's difficult. What makes it difficult?
What makes the taxation of the digital
Well, the following up
economy
and determining the details that
The
pertain
market rate
and so forth. What makes it difficult?
It's because some of these services, they are monopolistic. You'll find that only one entity is actually providing them, or a couple of entities that you can pretty much count. So it becomes difficult to price them because it's still something new. It's still sort of like a new service. The other issue is, of course, the fact that these DTEs do not provide for their taxation. For instance, there's this concept of you will tax a particular entity based on whether it has a fixed place of business in your country for a certain period of time. But you see, the models that we have with digital businesses is that they don't have to physically be in your country for them to carry out substantial economic activity within your country. So it's very hard to sort of deal with those issues when the double taxation agreements that we have do not provide for them. That's why you've seen there's been a lot of clamor for coming up with digital service taxation. Like many countries within Africa, including Kenya, through the recent enactment of the digital services tax, is really trying to respond to the growth of the digital economy and come up with new ways of taxing them.
But it's still not clear, even with the new digital services tax that's coming into effect in the new year. I mean, an organization, let's say Amazon, you are able to go online and to make a purchase, and you can trade on Amazon or even Alibaba. So how do you, as a country, say that this is business that happened within the borders of the Republic of Kenya, and therefore Amazon or Alibaba, you should pay tax in Kenya? How do you get them?
It's very difficult. It's still an argument at global level. People are still coming up with a lot of various proposals for it. And one of those proposals is that there should be a minimum global tax that these companies pay, specifically to market countries such as us, to places where there are numerous consumers. But there are also a lot of questions regarding that. For instance, how do you verify the number of consumers or the users of that particular service that you can determine that they are substantial enough for you to tax them? And considering the fact that in Africa specifically, especially within our neighbor Uganda, there's wide use of VPN where people pretty much hide where their locations, where they are. So it's hard to sort of decide to tax them and sort of decide that these people, there's substantial economic activity in this particular area so that we can tax them. But what is most important is that African governments and the Kenyan government itself really needs to wake up and respond as much as possible to this. It won't be a perfect process, in my opinion, when it comes to taxation of the digital economy, but it's all about learning and responding as much as possible and trying to capture these revenue leakages that we're experiencing as a country, so that we can really stop resorting to unsustainable financing.
So now these leakages that we are seeing, they're across board and they have been accepted that they're happening. Who really gains if things are maintained as status quo? Who gains right now?
The people who are gaining are these big corporate entities, multinational entities. Even during COVID, you had that there are some people and there are some companies that have really been making substantial profits. And yet you'll find in some countries that they also benefited from the reduction of corporate income tax, these response measures that were made towards COVID-19.
Yeah.
So they're the ones who are gaining. The governments are not gaining. The normal citizens of Kenya, we are losing out a lot through these double taxation agreements. And
So
we really need to wake up.
So what would it take, once we are awake, what would it take to break all of this down and say we're in a position, I mean, taking into consideration state sovereignty and things like that, what would it take to break this all down and say, look, we need to either start from scratch or we need to scrap these things completely? Because you'd rather not have it. I mean, there's no difference. Whether you have it or not, right now, it wouldn't make a difference. You're not gaining anything from it. So yeah, you have an entity set up, you have contracts in place, and the government gains nothing. You'd rather not have it at all, right? So what would it take to take it all apart and to start from the beginning and say, this must be set up in a certain way so that the government also does gain, so that the people of Kenya gain? What would it take to do that?
The first thing that it will take is that we need to sit down and review all the double taxation agreements that we have signed so far as a country. We need to do that. The other thing is, even as we're considering signing new double taxation agreements with other countries, for instance, I have noted that we're in the process of signing a new one with Portugal. We're in the process of signing another one with Turkey. We really need to do a cost-benefit analysis. Is this really adding value to our economy, or is it actually making us lose substantial amounts in terms of revenue? The other thing is we need to increase the participation of the public. We need to make this a very, very transparent process. The cost-benefit analysis should be visible, should be seen. It shouldn't be behind closed doors with experts. It needs to be something that is broken down. We also need to increase parliamentary participation in these processes. It shouldn't just be a matter of the executive that they really have no one to check them on. It should be something that is of public interest and something that should therefore be in the public domain to the fullest extent. So I think that's really the next step. Reviewing them and cancelling whatever DTAs are not helping us, completely doing away with them. And I need to also mention that we won't be the first country that does it. We have had Senegal as well as Zambia actually cancel the double taxation agreement that they had with Mauritius, because they considered them and they saw that they only cause serious harm to their economies and they cause them serious revenue leakages. And so there's no need of pursuing something that is eventually causing you harm.
Has Kenya made a consideration about the DTAs with Mauritius, for instance?
Well, that's where we come in as the Tax Justice Network as well as the East African Tax and Governance Network. It's because we went to court when the first Mauritius double taxation agreement was signed, and we challenged it on the basis of some of the provisions that it was providing for that were eventually going to cause us a lot of revenue leakage, as well as the process in which it had been signed, because there was really not enough adequate public participation, and also there was just not enough transparency surrounding the whole process. So this actually led to the nullification of that first double taxation agreement. But as we've seen, the Kenyan government went ahead and signed another Mauritius double taxation agreement. And it isn't in any way more favorable than the last one. It's just that they decided to be a little more transparent with what they were doing this time. But in terms of the substantive provisions, there's no improvement within that agreement. And really, it makes us wonder, what is this that is making the Kenyan government pursue such unfavorable and disproportionate double taxation agreement?
What's your hunch? What is making the government do this?
I think it's more of a political process than it is an economic process. And that is why we really need to check them.
So we've thrown the baby and the bathwater to the politicians yet again.
Pardon?
We've thrown the baby and the bathwater to the politicians yet again, meaning we've gone round in circles, but we've said, okay, the politicians have come. Let me ask this question, this double taxation discussion, does it in any way apply to the county governments and their relationship with the national government?
That's a really, really good question. Yes, I think it does in fact apply to them. I'd say indirectly at this point, because at the end of the day, when it comes to public finance, when it comes to public resources in terms of our finances, they both have a role and responsibility towards it, especially when it comes to the Article 201 of the Constitution on the principles of public finance has really broken it down well, that there are instances when there are any bills or there are any bills that are taken to Parliament that have to do with money, which includes also tax, then they have to involve both houses, where you see both county representation as well as the National Assembly representation. So to a certain extent, yes, they do involve county governments, and they can pressure the necessary people to really check these processes of double taxation agreements. This is a really contentious point of law, if you allow me to say that, because when you look at the legal framework surrounding the formulation of double taxation agreements, it really does not allow for enough parliamentary participation if you really look at it properly. For instance, you look at the treaty-making laws of Kenya, and you'll find that they differentiate what we call treaties with bilateral agreements. So bilateral agreements are agreements that pretty much have to do with administrative issues as well as executive issues. You know, they're pretty much government business, while treaties can be about human rights and issues that affect public interest. So the threshold of parliamentary participation when it comes to treaties is very high. In Kenya, we can't domesticate a treaty without parliamentary participation. They have to approve of that particular treaty. But when it comes to bilateral agreements, it's pretty much the ambit of the executive. It does not require parliamentary approval because it's government business. It's a technical issue. The parliament does not really need to get involved in that particular issue. And so when we consider double taxation agreements to be bilateral agreements, we're really cutting off the participation of parliament in that particular area, simply because we view tax as something technical, something executive. So we're pretty much saying that this is not your business, parliament. You leave it to us. That's the problem with the legal framework that is surrounding the formulation of double taxation agreements. There's really a lot of arguments there. There are a lot of, it's a contentious issue. It's something that's being debated on right now. But it's something to really think about, that in the first place, we don't have laws that provide for adequate parliamentary participation within the formulation of double taxation agreements.
Everlyn, we want to thank you very much for speaking to us. Everlyn Muendo is the legal officer at the East African Tax and Governance Network. We thank you very much for sharing all those insights with us. I think this is another conversation that deserves a revisit, so we can come and look at what kind of agreements we have so far with the country, how they're affecting us, how they're impacting on our own revenue collection, and also just keeping the money that we raise. Asante sana, and we wish you a good day.
Thank you.
Thank you.